Patent Bar Unlocked, and this video is part of our series going through modernized questions from the USPTO patent bar that were given in 2002 but have been updated to be in line with modern law. This question is about amendments to PCT applications. The original question 3 from the April 2002 exam is one of those questions that relies heavily on a very old rule, in this case one that was actually changed back in April 2002 about the timing of national stage entry for PCT applications, so I've adjusted the question to reflect current law. So it says, Belle Bordeaux files a French patent application for a rejuvenating lotion in the French Patent Office on January 10, 2024. On January 10, 2025, she files a PCT application in the EPO receiving office claiming priority to the French application and designating the U.S. In May 2025, the EPO, acting as International Search Authority, issues an International Search Report and written opinion raising novelty objections to several claims. Bordeaux meets with you in September 2025 to discuss her U.S. filing strategy. She wants the opportunity to amend her claims and have those amendments formally considered by an international examiner, producing an official report reflecting the amended claims before entering the U.S. national stage. Which of the following best achieves this objective in accordance with current USPTO and PCT practice? There are a few options here, but before deciding on a correct answer, let's go over a few terms here. So, what is a PCT application? PCT stands for the Patent Cooperation Treaty, which is a set of rules allowing inventors to file a single application which can then be directed to any of the countries involved in the treaty. Let's say you invented a widget and wanted patent protection in the US, Germany, and Japan. You could file one PCT application and then use that application to enter the national stage in the US, Germany, and Japan. Note that the PCT does not grant a patent and there is no such thing as an international patent. Rather, it streamlines the filing process so that you don't have to start from scratch in each individual country. When you file a PCT application, it will receive an initial look from the International Search Authority, who will issue an International Search Report. This is an official but non-binding document that identifies prior art relevant to an invention, lists relevant patent documents or literature, and categorizes them to show if they affect the novelty or inventive step of the claimed invention. After receiving the ISR, an applicant has the option of filing a Chapter 2 demand. This is an optional request for international preliminary examination under Chapter 2 of the PCT, allowing an applicant to respond to examiner objections, amend patent claims, and receive a non-binding patentability report before entering the national phase. Another term that you might see here is in answer choice B. It mentions a bypass application. Now, if you're not sure what that is, that would be an excellent search term in the MPEP, Chapter 1800. A bypass application is an alternative way to enter the U.S. patent phase by filing a new continuing application that claims priority to an international PCT application, completely skipping the traditional national stage entry. So now that we've got these out of the way, when answering questions on the exam, it's really good practice to start by identifying exactly what the question is asking. In this case, it says that the applicant wants the opportunity to amend her claims and have those amendments formally considered by an international examiner. So then let's take a look at the answers. Overall, this is a question I would recommend knowing the basics and using logic to determine the best answer. But if you needed to check on something, Chapter 1800 of the MPEP has all the details on the PCT. You could check definitions such as bypass, and if you wanted to see a layout of the basic PCT timeline, you could find that by using the table of contents and going to the chapter on the basic flow of the PCT. So answer choice A, actually take a minute and read through the answers and choose the correct answer. Okay, pause the video if you haven't chosen an answer yet. Let's go ahead. So answer A can't be right because the written opinion that Bordeaux has already received is for her original claims. And that wouldn't answer what the question wants us to find, which is a chance to look at amended claims. Answer B, Bordeaux should file a bypass application. also can't be right because the bypass application, while it can contain new matter, wouldn't involve any international phase amendment or international review, since it's a way of bypassing traditional national stage entry. Answer C is promising, though, because the Chapter 2 pathway allows for amendments to the PCT application. Answer D is definitely incorrect because the 30-month national stage deadline is fixed regardless of whether or not a demand is filed. So overall, answer choice C is the best answer, since it's the only one that will allow for consideration by an international examiner rather than a domestic examiner in the US. Thanks for being here for this question. Next up, we'll be looking at filing an information disclosure statement after a notice of allowance. If you're looking for more free study resources, check us out at patentbarunlocked.com. Thanks, and we'll see you next time.